Hello everyone and welcome to an exclusive interview with Mr. Diptangshu Shukla, who is a lawyer and a men's rights activist. Today we are here to discuss about a very critical law, that is 498A, which was actually made to protect women from any kind of harassments or abuse in the hands of her in-laws after her marriage. But sadly, today the exact opposite is happening. Women are actually misusing such laws, which were meant to protect her, and filing false cases against their husbands. And such false cases ruins the entire life of not only the man but his family as well. So it is very important for every man and his family to know about such laws. And Mr. Diptangshu Shukla is such a man who has himself fought such a false 498A case and has also won, which is a very big achievement. So let us see what he has to say about this. So hello, Mr. Shukla, and welcome to Foreman. So regarding
Hello,
today's topic,
Namaste.
if you talk about, then it is about the law that protects women, but like the laws like 498A and the domestic violence laws or the DV laws, but there is no any such law which can protect men from any kind of harassment faced from the wife. So, if we talk about the 498A, then what precautions can a man take to save himself from a false 498A case?
Uh, a 498A case IPC can be filed by any woman, any married woman, against her husband and relatives on simply a statement which she can give to the police. So, a very short answer to your question would be that there is practically nothing which a husband can do to stop a woman from filing a false 498A case. But what he can do is take certain precautions, because when the law is not on your side, you can gather evidence to prove your point, to create a good defense that you have actually not meted out cruelty to the wife or taken any dowry, demanded any dowry. You can keep collecting evidence of your innocence. As soon as you start getting any threats of implication in such false cases by the wife. So that is all a husband can actually do. Secondly, what he can do is he can probably inform, give an informative to the police regarding such threats which have been issued, and request them that if and when any complaint is received by the police, they should do a fair investigation. Because as an innocent accused, what a husband can fairly demand is a fair investigation of the case. That is his right.
Okay. Yes, that is true, because what we generally see is that the woman files a case and she alleges the husband of many things, but in most of the cases, the police does not even listen to the husband that what he wants to say, or maybe sometimes the woman, she does not have any evidence, but still the case is going on for a long period of time. So that is something very difficult, that makes the life of that particular man and his family much more difficult, and that is really something very important that we need to discuss with the people, with the public, so that they come to know about such laws and how they can prevent themselves, or what are the precautions they can take to prevent themselves from such kind of false cases.
True, because you are right that in most of these cases, it is simply on the basis of a statement that an FIR is registered. And other than the wife's statement, there could be statements of our father and mother or all blood relatives who are biased witnesses, who are not neutral witnesses. So, simply on the basis of these three, four statements, a case is registered. All that is available in the form of documentary evidence is a marriage patrika or a marriage certificate, which only actually proves that a marriage exists. It doesn't prove that harassment exists. On the other hand, husband might have a lot of evidence in his favor, such as certain bank transactions, receipts of expenses that he may have spent, or recordings, audio or video, which show that there has been no dowry dispute or any cruelty between the families. But all of the evidence from the husband side is usually not looked into by the police. They should ideally look into it, because as an investigating agency, they are supposed to do a fair investigation. If they actually do fair investigation, then my guess is that in 70 to 80% of the cases need not go to courts at all. They can be
True.
disposed of at the police level itself.
Yes,
And that
yes.
would be a great service which the police can do to the nation, because our courts have been jammed with such false cases which keep going on for years and years together.
Yes.
Now, who actually benefits from these false cases? If there is some actual victim of such kind of atrocity, then that person may not get enough hearings from the court, because the courts are already clogged with false cases. Whereas a person who is falsely accused, which happens in most of the cases, he has to keep going to court again and again, and that becomes a harassment in itself. So even before a punishment or acquittal, whatever happens, and the trial is concluded, the ordeal of a criminal trial itself is unbearable for at least a large majority of accused in these cases, who come from very good families. Most of the accused you will find are from very educated people, decent middle class families,
Yes,
upper
very
middle
true.
class families. Unlike other IPCs, like the reason why we are discussing these particular sections is because the accused in other cases, if there is a, say for example, a murder case, you will find accused who are come from probably a criminal background, or who have not got very good education. And people accused in thefts also come from these kind of backgrounds, generally speaking, not in all the cases. But in generally speaking, in 498 cases, most of the accused, you will find them to be very well educated: software engineers, doctors, even advocates, judges. There are several cases on judges as well. So yeah, this particular section needs to be properly investigated whenever there is a complaint filed under this section.
And how does a man prove that that he has not taken dowry in a false dowry case? Because we generally see that a woman, they file a false dowry case, but there is nothing that a man can do to prove himself that he has not actually taken dowry. So what can someone do to save himself from such kind of false cases?
See, our criminal justice system is based on the concept of proof beyond reasonable doubt, and the prosecution has to prove the case beyond reasonable doubt. So if the allegation and the charges are of IPC 498A, then it is the prosecution who has to make the entire case and prove their case beyond reasonable doubt. It is not for the husband to prove that he has not taken dowry, but it is for the prosecution to prove that he has committed cruelty, either of an extreme nature, which compels the woman to suicide, or cruelty with the intention of meeting certain demands. However, certain sections like 304B of IPC, which is Dowry Death, and Dowry Prohibition Act 1961, these are special provisions, and to bring more stringent effect to these laws, there have been even changes made to the Evidence Act. And once the basic ingredients of the offense are proved, the burden shifts on the accused. So you are right to a certain extent that if the basic ingredients are proved by the prosecution, the burden will shift on the accused, and it is for the husband to prove that he has not taken dowry. To give you an example, that if there has been a transaction between the parties whereby the woman's family has transferred some amount in the husband's family, then the prima facie case of Dowry Prohibition Act 3 is established. And it is for the accused to prove that this transaction was neither a demand and it was not related to any sort of dowry. Now, to answer your second question, that how will a husband prove that he has not taken it? So as I said in my first precautions to be taken by husband, what a husband should do is, once there is a threat of any kind from either the wife or any of her relatives, then the statute is not in favor of men. The law is not in favor of men. So what can be in favor of men is the evidence. So he needs to start gathering evidence of his innocence. It doesn't mean he has to show all of his evidence while the prosecution evidence is going on. But when the time for his defense comes, he can have certain witnesses or submit certain documentary evidence, some of which can also be submitted during prosecution evidence, which will cut the prosecution story. So which will bring out loopholes or lacunae or bring out the falsity of the prosecution story, which will make their case extremely fragile, and there can be an acquittal in the case. So in short, he needs to gather evidence of his innocence to be used at the right time in trial.
Okay. And when we talk about fighting such cases like this false 498A and whatever such cases are, so it involves a lot of money. It requires a lot of money to fight such cases. So if a man is from a poor economic background or he's not earning that much, then what can he do in that case?
First of all, whether a man is from a poor or a rich background, he needs to formulate a strategy of fighting the case. Initially, there is a lot of panic, particularly because, as I said, people come from very educated backgrounds, and even a phone call from the police or a summon to the court can put them in great panic.
Yes.
So rather than taking impulsive decisions like immediately going and filing a restitution of conjugal rights case under Section 9 of Hindu Marriage Act to bring back the wife, or filing a divorce case immediately without proper preparation, what a husband should do in such cases, whether rich or poor, is to formulate a proper strategy. Then once there is a proper strategy in place, then there has to be a defense carved out at the very beginning. Because what is your side of the story? You need to start building it from the very beginning. If you simply find out loopholes in the prosecution story but not have a story of your own, then there will be times when probably a divorce case is also simultaneously filed by the wife, or a maintenance case is filed, when you have to submit your side of the story. So once you have a proper defense, that what are the list of evidences that you have, what is your side of the story, what is the actual story, then you can easily prepare for all of these cases. Now, if a husband comes from a poor background, what he needs to do is separate the criminal cases from the civil cases. In the criminal cases, what he should try is to get a very quick trial in the courts. Because if he is innocent, then he should get out of that ordeal as soon as possible. It will not only save his resources, but also bring the opposite party in great dismay, because one of their strategies in these such cases is to cause a lot of harassment through criminal trial. Now, when the criminal trial is passed in favor, is decided in favor of the husband, then half the battle is won already. So that is one strategy. What he needs to do in the civil cases is, he first of all should not be filing cases unnecessarily, like divorce case or restitution of conjugal rights case. He should wait for the right moment. For example, if a husband is acquitted in a 498 case and then he files a divorce case, then he has a much better chance of getting a divorce decree in his favor, because filing a false case has been considered by the Honorable Supreme Court to be a severe kind of mental cruelty on the husband. So on the cruelty grounds, he can get a divorce. As far as the other civil cases are concerned, the maintenance case is concerned, a person from a poor background can fight his own case also. The law gives him the right to fight his own cases, not only in maintenance, but also in 498A. However, in 498A criminal case, I would not recommend every person to go and fight his own case, because even a single mistake in a criminal case can really bring you down, and the stakes are very high. So there you should not be playing a risky game. But certainly in a maintenance case, you can fight, the person from a poor background can fight his own case. There are already formats available in which you both sides these days have to file affidavits as per Rajneesh Neha judgment gone to the Supreme Court. So simply he has to download the affidavit format and submit it in court. He should be very truthful in filing the affidavit. If he's from a poor background, certainly his income will not be shown too much, and chances of a maintenance in his favor against him will be quite low. Simultaneously, what happens in maintenance cases is there are instances where the wife has been known to exaggerate the claims about income of the husband and downplay her own income. So the husband has to be alert about these things, and if there is a false affidavit of assets and income filed by the wife, he should move an application for perjury, for contempt of court. So what happens is, if you very forcefully make sure that the opposite party does not go scot-free by lying and making false statement in the court, then chances are that an order in your favor may come. Whether it is zero maintenance or a very low maintenance, or in some cases we have seen that if certain false statements of the wife come on record and are taken seriously by the court, the entire case can also get dismissed.
Okay.
So this is how a person from a poor background can fight a case.
Yes, and that's true. And regarding the maintenance also, like most of the time we see that the husband, he is required to pay the maintenance to his wife, no matter how much he is earning, but still he has to pay the maintenance to his wife. And even the wife is capable enough of earning and she is well educated, then also she is not working, but she is dependent on her husband for maintenance. And in very rare cases, we see that the wife is paying some kind of maintenance to the husband. So this is something which I personally feel is very unfair. And these things needs to change, because a wife totally cannot depend on her husband for her lifetime. Because we also have to see that how much the husband is actually earning, because whatever he is earning with that amount, he has to run his household also. And now a woman who is not with him anymore, now he has to pay her also, even though she is capable enough of earning all by herself. So
there have been several judgments which say that the husband has to either beg, borrow, or steal, but he has to pay maintenance.
Yes.
That is his duty. At the same time, there are also certain judgments regarding certain neutral provisions which we have, like Section 24 of HMA is a neutral provision, gender neutral, in which both the husband and the wife can demand maintenance. Although it is on very rare occasion that we have seen that the husband gets maintenance from the wife. But if you have to get around these kind of provisions, then what you need to do is a proper background study about the income and resources of the wife. So as I said, that there is a requirement to file income and asset affidavit by both the parties after a recent Supreme Court judgment in Rajneesh versus Neha. We have to ensure that the affidavit being filed from the wife's side is the right affidavit and there are no mistakes in there. If there is an omission or an intentional false statement, we should pursue it very thoroughly and seek prosecution for perjury.
Okay. And now, as we can all see that there is a trending topic going on, that is the marital rape. So there is a PIL for it, that the court needs to criminalize marital rape. So what do you have to say about this? Is it required to criminalize marital rape, or there is something called marital rape? What do you have to say about this thing?
Firstly, to be fair, marital rape is not really not criminalized. It is already criminalized under certain conditions. If you look at IPC 376B, a husband who is living separately from his wife, either under a decree of separation or otherwise. If there is intercourse by that husband against the will of the wife, then it is punishable, and punishable up to 7 years of imprisonment. So under that condition, where normal relations between husband and wife are not expected, marital rape is punishable. Similarly, even under normal circumstances, when the husband and wife are living together, Domestic Violence Act criminalizes marital rape. So very explicitly, very clearly, sexual violence has also been termed as one of the categories of domestic violence. And once a protection order is obtained and there is a violation, then person can certainly be put behind bars for marital rape, even under the Domestic Violence Act. So to say that it is not criminalized is not entirely true. Now, what the people are seeking is to get a higher punishment.
Yeah.
So that
it's
the
like the
exception
wife
is-
will go and say that my husband has raped me and he needs to get the punishments. That is something very wrong.
Right, because there are several practical difficulties in this. First of all, of course, it is not gender neutral. Only one of the parties will be able to file marital rape case on the other. And secondly, in behind closed doors, what actually happened, nobody really knows.
Nobody knows. Yes.
It will be one word against the other. And are husbands supposed to keep CCTV cameras in their bedrooms? I'm not really sure. Or should they be signing some consent form before the act? So,
Yes.
there is only a limit to which the law should try to enter into people's lives. And the law has also already entered their houses. In fact, law has already entered their bedroom. Now, this would be going even further. So, see, there is no extent to which law can go. For example, if something is already criminalized, then you do not need to have a very special provision or to equate it with a more severe provision.
Yes.
For example, if there is there is already a punishment for assault, then you don't need to have a separate IPC section to punish slapping by a person, because it would come under some kind of assault already. So having a very specialist provision for marital rape when there are already existing provisions, and is certainly, I think it would be another family breaker law, just as 498A has also turned out to be. And one of the consequences which people may see would be that there will be more marriages which will end up in divorce, because what has been a very common observation in all the cases that we handle is if a wife has filed a maintenance case or a divorce case, there is still scope for reconciliation between the parties. But once there is a criminal case filed, either it is 498A or certain Domestic Violence Act with certain protection orders, then the scope of reconciliation between the families is gone, and the family cannot be reunited. So this will be another law which will be breaking our families, and something which we should have been proud of, and the Western society we had been the envy of Western society.
Yes.
Will disintegrate.
Yes.
So it is certainly
And that's
not
what
good
is
for
actually happening now. People are afraid to get married because of all these kind of biased laws. And I do not
Right.
know why that nobody is bothered to amend these laws. That's the biggest question, why.
Yeah, the
So-
most basic amendment which should happen in all of these laws is they should be made gender neutral,
Yes.
and there should be a provision for punishment if there is a false case
False case,
registered
yes.
by any party.
Yes.
So because we are recognizing that women have come up a lot in society, they now stand equal to men in regards to working in private sector, in government sector, even as members of parliament. So when they have come so far, even there was a recent report that the ratio of the gender ratio in India has
Yes.
improved a lot. It has gone
Now its
above
female is
1,000.
higher. The
Yeah,
female
it is
ratio is
higher.
higher now.
Right. So I think the policies which have been taken in the past Maybe they had some logic at that point of time,
Yes.
even though they did not really work according to me. But they may have some logic at that time. But now is the right time to make all these laws gender neutral.
Yes.
It is high time.
Yes, I totally agree. I totally agree. And we also have some questions from our followers for you. So I'll just ask them one by one. So number one question that you have is that neither I nor any of my relatives demanded or have taken any dowry. Can she still file a 498A?
Short answer is yes. As I said, the all a person needs in order to file a 498 case is a statement. Now, the general feeling among people is that how can a case be registered on the basis of a statement? But oral evidence is also a very strong piece of evidence. It is considered enough prima facie evidence to proceed with registering of a case. In fact, Supreme Court has very clearly said in Lalita Kumari's judgment that if there is information about a cognizable offense, the police is bound to register an FIR. So the husband and their family should not be in any false impression or false hope that just because they have not taken dowry or demanded dowry, done any cruelty on the wife, case cannot be registered. Because registering of a case is not conviction. Certainly, if they have not done anything wrong, they will not be convicted. But a case can certainly be filed against them. So they should be cautious. They should intimate the police timely, give informative to the police. They should also collect evidence. And if a case is filed, they should ask the police for a fair investigation. And in certain cases, approach the High Court for quashment of the case if they have enough grounds to do so.
Okay. Number two question is, my parents never stayed with us. Can my wife still file a 498A case against them?
Yes, short answer is again yes, because nobody can stop a person from filing case against others. And if the police would do a fair investigation, which sometimes they do, then certainly the names of the parents can be removed from the FIR. But if there is no fair investigation and just a mechanical filing of charge sheet, which is done in most of the cases, then the names of the parents will also be there. However, if the parents have not been staying together, then I would highly recommend that a quashment application under Section 482 of CRPC should be filed by the parents before the Honorable High Court of appropriate jurisdiction. And on the basis of several judgments, one of them being Geeta Malhotra versus State, they can seek quashment or cessation of the trial against them, the charge sheet.
Okay. Number three, my wife and her family are demanding money, joint property, joint account, separate accommodation, jewelries, etc., and are threatening that they will be filing a 498A if their demands are not met. What should I do?
First of all, as in all other situations, you need to collect evidence of all of this. Once you have evidence of this, if she is insisting on living separately from your parents, it comes under the grounds of cruelty for seeking divorce. Other than that, if she is also threatening of filing of false cases and asking certain monetary favors, then that comes under extortion. It is actually punishable under IPC. So the very basic thing which a husband can do is record evidence of all of this and proceed with a divorce case. So, later on, if the wife files any counter cases, like 498, a domestic violence case, after his divorce case, then such cases can be, there is a prima facie impression in the mind of the judge that these are counterblast cases which have been filed after the husband made his move. And so certainly husband is the aggrieved party. So this is certainly a husband should do, collect the evidence and file a divorce case. If he has a lot of proof about extortion bids, then there is also a possibility of filing an IPC 384 case for extortion.
Okay. Number four, I fear that if the police take any action on my complaint, my wife will lodge a 498A immediately. should I still submit my complaint?
See, you can submit a complaint with a request to police that you do not want any action on this complaint. All you are telling them is to do a fair investigation if at all any complaint from the wife side comes. So that you can do.
Okay. And we have the last question. When the station in charge of police station does not register the case, what can I do in that situation?
Yeah, this is a very common question actually. A lot of people think once the police is not taking their complaint, that is the end of it. Kya kare? But there are several steps which they can do. The first step is to give complaint in writing. Never do things orally, because there is no record of any oral complaint. If you give it in writing and try to get a receiving from the police, if the police for some makes some excuse and does not take the complaint or does not give you a receiving for it, then you should send the complaint by registered post and keep a record of the receipt. Secondly, if there is still no action on it, then after a few days, you should send a copy of the same complaint to the Superintendent of Police under section 154(3) of CRPC. The Superintendent of Police may then forward that complaint to the concerned Thana in charge to take action and register an FIR. If that also doesn't work, then you should pursue both of these complaints through RTI. You should file RTI and ask them what action has been taken on your complaint. Finally, after you have done all of this and still it doesn't work, there's a very good chance that if you take all these steps, the FIR will be registered, or at least you will be called for statements, your statements. If still it doesn't work, then you have the option to go to court and file a private complaint under section 156(3) of CRPC. Under that section, the court may take your statements or direct that an FIR be filed. If the court takes your statements, then the case gets registered as a private complaint with cognizance being taken by the magistrate under section 200 of CRPC. However, it would be preferable that an FIR is registered, because in a private complaint case, the complainant has to keep going to court all the time, and there is a need for him to hire a private counsel. Whereas in a case in which FIR is registered, it is the state which fights the case, state versus the accused. So having a private counsel is optional, and the complainant also needs to go to court only when her statements or his statements are needed.
Okay. So I am really hopeful that all this information will be very much helpful for the people, because I personally feel that every man, every boy, and every family who has a son needs to know this kind of information, because we never know what's going to happen the very next day. We never know, and we do not hope that, we do not even want anyone to go through all this kind of false cases, but no one knows what's awaited for them in the future. So here we come to the end of today's discussion, and I'm very much thankful to you that you took out time for us and helped people to know about so many kind of important information. And I'm also hopeful that very soon we are going to have a general neutral laws in our country, and we will be living a better place soon. Thank you so much once again. And
thank you so
also
much for having me in, and particularly for taking up such an important topic. It is not often that these topics are taken up by the media, and you as a media house have taken up this topic. It is very commendable. You have gone against the flow and towards a better society. This is an effort towards a better society. The first step is awareness, and the second step would be gender neutral laws. So thank you so much.
Thank you so much, and I'm hopeful that we will be again meeting for another conversation regarding such kind of biased laws and how we can prevent ourselves from suffering from all this kind of false cases. Thank you once again, and see you soon again. Namaskar. Thank you so much.
My pleasure. Namaste.